Well, good afternoon, everyone, and welcome to panel 3, to those in the room and to those who are watching us remotely. My name is Dario Milo. I'm a South African lawyer and academic, and I'm also a member of the high-level panel of legal experts on media freedom, for whom SLAPPs is a focus area, and it's an important part of our existing work on the safety of journalists and other human rights defenders. It's great to be here in person this year. I was participating virtually last year, and it's so nice to see so many friends and colleagues and champions of this area of law generally and freedom of expression. And thanks, of course, to the Foreign Policy Center, Justice for Journalists, the IBA, Human Rights Institute for hosting this event, and for all the efforts and monumental efforts at that of a lot of people in this room for making this a priority area in actually such a short space of time on the continent. And the topic that this panel is going to talk about, I think, is critically important. It's about legislative measures to deal with SLAPPs, the pros, the cons, and I'll shortly introduce our panel. When I addressed you last year, I spoke about a South African case that was then on appeal to the Constitutional Court, where I acted for a number of environmental activists and, in fact, also some environmental lawyers who had hosted a session at a summer school at University of Cape Town. And they were being sued by an Australian mining corporation that's engaged in quite extensive mining activities on the west coast of South Africa, Mineral Sands Project. In fact, the name of the corporation is Mineral Sands. And 3 defamation claims had been brought against my clients, totaling 14 million rand, which is about 700,000 pounds at our quite shocking exchange rate as of this morning. We don't have SLAPP legislation in South Africa. And in fact, it's not at all common in Africa to find SLAPP legislation. And so what we argued was that there is a defense of SLAPP or anti-SLAPP, which you can argue as a species of abuse of process in the common law of South Africa, and particularly in the defamation context. And I'm very pleased to report back that just 2 weeks ago, the Constitutional Court in South Africa, which is our highest court of appeal, agreed that a SLAPP defense is a competent defense to raise as a species of abuse of process in our common law for meritless claims, and as the court put it, where the odious ulterior purpose is preventing or prohibiting discussion on public issues. And I might add, although it's not a SLAPP-specific argument, we also raised a second defense, which is that a corporation has no right to sue for general damages in defamation law. And I'm pleased to say that the Constitutional Court upheld that defense as a general proposition if the speech is on a matter of public interest. So it seems to me that the 14 million rand that the Australian corporation is seeking, that is simply not going to see the light of day. And I hope you'll agree with me, certainly for South Africans and for the continent of Africa, where this judgment will set the tone. I hope you'll agree with me that this is a moment of celebration for us. But at the same time, the judgment, being a common law creature, doesn't set out a detailed, comprehensive regime for dealing with SLAPPs. And indeed, the court itself emphasized that this kind of detailed regime must come from Parliament, which is the engine of law reform. And of course, this is a useful segue to today's panel, because we're going to get into the weeds, I think, of some legislation that's been around for a while in the United States and in Canada, and legislation that is being proposed in the EU and the UK. And we're going to try and understand some of the critical elements of those and how respective regimes can, or respective jurisdictions can inform each other. So we're privileged to have today on our panel experts from the United States, from Canada, and we have 2 panelists speaking about the European and the United Kingdom developments and in the context of the existing SLAPP landscape. So on my left, and this panelist will go first, is Laura Prather, who is a partner at Haynes and Boone in the United States. We have virtually Prof. Chris Tollefson, who is a professor at the University of Victoria and the executive director of the Pacific Center for Environmental Law and Litigation. Also, and I'm just reading them out in the order that we'll hear from them, also remotely is Flutura Kusari, who is a legal advisor of ECPMF and a member of Council of Europe's experts. And then, of course, Charlie Holt on my far left from English Pen and the co-chair of the Anti-SLAPP Coalition. So I'm going to invite each panelist to give us some introductory remarks on this topic, legislation to regulate SLAPPs. And then there will be a roving mic, so please raise your hands. We'll take questions. And for those who are participating remotely, I'll be trying my best to navigate the questions on the other device over there. So perhaps without further ado, Laura, would you like to open up
I'd be happy
the discussion?
Thank you, Dario. So I'm going to attempt in a short period of time to give a bit of a historical perspective about anti-SLAPP laws in the U.S. and bring you up to date on where things currently stand. The concept of SLAPP started in the late 80s with an article that was authored by two professors, George Pring and Penelope Kanian, that basically had evaluated the influx of lawsuits trying to silence people that were participating in public activities. And they coined the term SLAPP, Strategic Lawsuit Against Public Participation. And shortly thereafter, the first anti-SLAPP law was passed in Washington state. It was passed in 1989. It was very narrow. It in fact just covered claims that were based on statements that were made to the government officials in the course of a government proceeding. But after that, things changed. In 1993, California passed a much broader law that dealt more widely with protection of any written or oral statement that was made in a public place or a public forum dealing with matters of public interest. And that really sparked the next 3 decades. The next 3 decades resulted in 34 states passing anti-SLAPP laws. There are varied degrees of protection, some limited in scope, some much broader. But what we saw in the decade of 2010 to the 2020s was a series of more than a dozen states passing very broad anti-SLAPP laws. And those anti-SLAPP laws all had key elements that provided protections that were integral in being able to continue the public discussions, the much needed public debate that had been silenced by this form of judicial harassment previously. And so what you had was the broad scope of protecting freedom of expression dealing with matters of public interest. You had an expedited dismissal process, which we discussed in some of the earlier panels, how important that is to basically stop the bleeding. If you're a victim of judicial harassment in this form, you need to be able to stop the bleeding quickly. And to do so, the judiciary has to take an active role in case management. And that may or may not be what they want to do, but that is an absolute necessity. And so this early dismissal framework invites, encourages, and mandates them to take that active role in judicial management at a very early stage. It also has burden shifting frameworks. So in the framework within most of the US states, the movement simply establishes that the law applies, that it falls within the framework of the protections of the law. And then the respondent has to establish that there is actually a significant basis, a likelihood of success on the merits for their claims. Then the respondent still has the opportunity to show that some sort of a defense applies. And that defense can be the basis for dismissing the case at an early stage. While all of this is going on, discovery is stayed. And I understand not everybody has discovery, but in the States, it's hugely expensive. It's time consuming, it's expensive from a monetary and a mental standpoint. It can put a halt to your newsroom activities because you're spending all of your time responding to discovery requests. So there is a stay of all of that while the judge determines if there is any basis for the lawsuit moving forward. And then once the decision is made by the court, there is the right to an immediate appeal of that ruling if the anti-SLAPP motion has been denied. And finally, the last piece of all of this is the recoupment of fees. If you've been the victim of this form of judicial harassment, you should be made whole. You should not have to then suffer also, even with an early dismissal, what can be crippling cost of the defense of these lawsuits. And so those are the key elements in these broad anti-SLAPP laws in the US. But they've only been passed in 34 states and the District of Columbia, and even then, it is a varied degree of protection. And so what you find is this checkerboard of protection invites forum shopping. So that forum shopping happens in two ways. You have people suing in states that don't have anti-SLAPP protection, and then you have people suing in federal court. We do not have a federal law on the books. And so in both ways, they can get around the protection. There are some federal courts that will apply the state anti-SLAPP laws, but that is, it is very complicated and differs substantially throughout the U.S. So one thing that's happened recently is in 2020, the Uniform Law Commission, which is a body of experts, lawyers, and judges from throughout the U.S., oftentimes appointed by state Supreme Courts or appointed by governors, they regularly get together and determine what areas of the law are so disparate throughout the U.S. but need a unifying force behind them, and they propose uniform legislation. One of the ones that is commonly known as the UCC, the Uniform Commercial Code, which has been adopted in all 50 states. They took on the task to develop a uniform model anti-SLAPP law. And it's a multi-year process that happens, and it gets ultimately approved by their board. And that law was, the model law, was adopted in July of 2020. And now, of course, that was during COVID, and so that has definitely slowed the efforts of getting it passed in legislatures because the legislatures have been dealing with COVID issues primarily. But we have seen Washington State already adopt the law, Hawaii, Kentucky. It's still under consideration in New Jersey. And it is definitely something that is being considered in a number of legislatures in 2023. They've already planned to look to that law and try to get it implemented in 2023. The hope with the ULC Model Act is that it will apply in federal law. In drafting the model law, they took great pains to try to make it so that it is seen as a substantive protection that will then be applied in federal court. That has not been determined yet, but that is the hope. And so that's sort of the state of affairs on a state level. On a federal level, as I mentioned, we don't have a federal law. It's something that we've been trying for 14 years now. So when I see the tremendous speed with which the EU and the UK are currently moving, it gives me great hope. But one of the things that has happened at a federal level recently is, for the first time ever, a bill was introduced in Congress in October of this year, H.R. 8864, by Representative Jamie Raskin, in which there was, prior to the bill being filed, agreement by the organizations, the human rights defenders, and the NGOs that have been proposing this legislation, and the trial lawyers. And that is the first time that those two groups have come together to propose legislation in an agreed upon manner. And so we have hope that during the next congressional session that bill will move forward. I think I'll stop there unless you want me to talk about anything else.
Thanks, Laura. I'm sure there'll be lots of questions. And it's striking for me how one thinks of the United States as pretty settled in terms of SLAPP law, but there's so much activity going on and efforts underway, just as here. I think we are ready to go to Chris. Chris, can you hear us?
Yes, can you hear me?
Yes, we can. Please go ahead.
Very good. Thank you. Well, I'm very happy to be joining you in this conference. I'm grateful to be here on southern Vancouver Island, which is a traditional territory of the Lekwungen speaking peoples. I've been working on SLAPPs now for almost 30 years. I started out working on this issue when I first became a law professor back in the early 1990s. And I've had, I guess, the benefit of looking at this issue both as a scholar, having written about the emergence of SLAPPs in Canada back in the 90s, but also wearing the hat of law reformer, and most recently as a litigator. We now have an anti-SLAPP law here in British Columbia that we're able to test and successfully use most recently this past summer. I guess what I thought I would do in my time, in my little introduction, would be to offer just a few observations emerging from our experience, my experience around the issue over that period of time. Firstly, I guess I would say this, that the road to getting effective anti-SLAPP laws on the books can be challenging. I mean, it's very encouraging to hear that headway is being made at the EU and in the UK. In Canada, progress was a lot slower. It took us pretty much from when the phenomenon was first identified in the early 90s, it took about 7 years to secure a law here in British Columbia, which was promptly repealed about 6 months later by an incoming government. So we had a law on the books for a very short period of time here in British Columbia. It took another 20 years to get a law back on the books here in British Columbia. We now have anti-SLAPP laws in the 3 largest Canadian provinces, and for the most part, they do resemble, they have most of the features that Laura has laid out. The reasons I think that the road was so difficult are various, and it's important, I think, for us to be mindful of them. One is obviously the inherent inertia, the difficulty of achieving any kind of meaningful law reform, regardless of the issue. This is also, I think, an issue that is a hot button one and can prompt significant opposition and hostility. And as well, in Canada anyway, I think there is some level of skepticism about how this issue gets framed as being an idea that was promoted in the US and for that reason is somewhat foreign to our legal culture. I think we've overcome that, but it was definitely a challenge. So that's the first thing. The second thing I think I would want to say is this. I think it's critically important to design laws that allow for protection for public participation where the court does not need to find that there was an improper purpose on the part of the plaintiff. In our first anti-SLAPP law here in Canada, that was a burden that had to be established. And even on a reverse onus, I think courts and even the most recent cases that we've been involved in underscore this. Courts are reluctant to conclude that there has been improper purpose on a summary footing. And so the new generation of laws do not require improper purpose to be proven, and I think that's a very important feature. Where improper purpose can be shown, of course, that does allow, and under our laws, to support a claim in damages, but it does not have to be proven in order to secure dismissal. The final thing, Dario, I guess I would say is this, that we often think of this as a legal phenomenon, but I really think SLAPPs are an economic phenomenon. This venue shifting is a strategy to benefit powerful interests, and it's very important in these laws to recognize that economic component. For that reason, I'm very happy that in the BC law and in the Ontario law as well, if you prevail on one of these motions, the presumption is that you get full indemnity costs, 100% of your costs. And I think that is a very powerful tool, both to hopefully discourage these suits from being filed, but also to level the playing field in these kinds of applications for dismissal. So, Dario, I think I'll just leave it there.
Thank you, Chris, and we all hope that the current efforts don't take as long as 2 decades to come to fruition, but it's lessons that are important to repeat. Prather, would you like to talk about the EU developments?
Yes, hi, can you hear me?
Go ahead.
Okay, great. First and foremost, I'm very sorry for not being able to be in London today. The conference looks great. Well done to Susan, Maria, and the entire team. I'm following it online with great pleasure. Now, in the next 5 minutes, I'll speak about the EU's role in countering SLAPPs. Now, we already heard today several times what SLAPPs are, how they impact the work of journalists and activists, and why we need to join forces to fight them. But it's never enough to repeat that SLAPPs are very dangerous to public participation. They are spreading secretly, well, not that secretly anymore, by targeting journalists and other public watchdogs in many European countries and beyond. In Europe, unfortunately, it took Daphne Caruana Galicia's life, for Europe to wake up and address SLAPPs. As you know, she was facing around 50 defamation lawsuits at the time of her brutal assassination. Since then, together with the Coalition on Anti-SLAPP in Europe, the case, the first European anti-SLAPP movement in Europe, we've been working day and night to motivate European institutions, but also governments, to react to SLAPPs. And you can already notice that we are a little bit proud of what we have achieved so far, although this is just the beginning of our anti-SLAPP work in Europe. On 27th of April this year, for the first time in the history of the European Union, the European Commission proposed an anti-SLAPP directive focusing on cross-border SLAPPs and also published a recommendation on anti-SLAPP. Now we're calling the proposed directive Daphne's Law. The proposed directive provides safeguards against manifestly unfounded or abusive court proceedings in civil matters with cross-border implications brought against natural and legal persons, in particular journalists and human rights defenders when they engage in public participation. The proposed directive covers matters of civil or commercial nature with, as I mentioned, cross-border implications. Now, the proposed directive includes key remedies and safeguards needed in any effective anti-SLAPP legislation. The proposed measures present solid but minimum standards which must be met to protect public participation. For us at the case, the initiative is a crucial first step forward in the fight against SLAPPs in Europe. Very briefly, I will mention the key features of the proposed directive. The proposed directive covers civil and commercial matters. It contains broad personal scope. Natural and legal persons are covered, journalists, human rights defenders, and others when acting on matters of public interest. Broad definition of abusive court proceedings against public participation, broad definition of matters with cross-border implications, which corresponds to the specific nature of SLAPPs. Now, the protection provided with the proposed directive is organized in 3 pillars. First is the early dismissal element, which is the most important aspect. So basically, to explain for non-lawyers, we want SLAPPs to be dismissed as early as possible by judges, so that journalists, activists, and those targeted with SLAPPs don't have to spend months, years, decades, and a lot of money and energy in defending themselves. That's why this is the most crucial aspect of protection proposed by the directive. And then the proposed directive contains other remedies against abusive court proceedings, awards of costs, compensation of damages, penalties, including the possibility of claimant to be able to be required to provide security to cover costs and damages. And also the third pillar is the protection against third country SLAPP judgments. Now, of course, this is very good, very much welcome, but we do believe as case that the proposed directive can be strengthened. For example, early dismissal should be available to any SLAPPs and not only to manifestly unfounded claims. Protective measures should be applied in all court proceedings against public participation. And we do have also other recommendations to improve the proposed directive. And for those interested to know more about what we're suggesting, everything is available on our case website. It's worth mentioning that we're working very closely with member states and the European Parliament to improve the current proposal and to gather support. My last contribution in this first set of input would be to mention a few words about the recommendation on anti-SLAPP. Now, while we wait for the proposed directive to be hopefully strengthened and approved, the recommendation on anti-SLAPP published by the Commission has already entered into force. The recommendation covers all types of cases, civil, criminal, administrative cases, both domestic and cross-border. It recommends member states to review the applicable legal framework to ensure that necessary safeguards are put in place. It recommends member states to offer capacity building for legal professionals, awareness-raising activities, and support mechanism, especially legal assistance. It also foresees that member states should establish focal points. And last week, since I'm a member of the European Commission Anti-SLAPP Committee of experts, we already met some of the focal points which have already been appointed by their governments. And lastly, it foresees data collection. Now, there is a lot of data, as you know, Mapping Media Freedom, Council of Europe Platform, CASE, and other organizations have done a lot of research and documentation. But it would be very much welcome to also see from member states data on available on cases of SLAPPs. There are developments at national level, but I guess I'll address that in the next round of contributions. Thank you.
Thank you very much, Prather. And 27th of April for South Africans is very momentous because it's Freedom Day in South Africa, the day of our first democratic election. So that's something of a good sign for the EU package. Charlie, would you like to tell us about the developments in the UK?
Thank you so much. Yes, absolutely. And actually, I'd like to start by just, as you said before, thanking our hosts, particularly Susan Cotree, my co-chair at Foreign Policy Centre, and also Justice for Journalists, who have been such an invaluable support with the making of the model law that I'm going to be talking about today. I know it's a bit of a faux pas to start a presentation by talking about myself, but I'm hoping in this case it's going to be merited. I joined the UK Anti-SLAPP Coalition early last year. Before that, I'd spent 3 years working in the US and 3 years working in Europe. My work in Europe involved initially in 2019 mapping out the problem of SLAPPs across the continent, so studying and cataloguing cases across the region. And when I joined in early 2021, Susan at Foreign Policy Centre had already been working to research SLAPPs in the UK. So I think this research work really complemented each other, and it gave us a good idea not just of the way SLAPPs work, but of the conditions that give rise to SLAPPs. And that's quite important to recognise, because when we put together and launched our policy paper in the summer of last year, it was really built on a recognition of these conditions. As has already been spoken, in fact, David Davis in the first keynote speech spoke about those 3 core components of the UK model anti-SLAPP law. We recognised quite early on that many of these conditions that we recognized as giving rise to SLAPPs came about due to an absence of safeguards built into individual laws and into the legal system as a whole. So, for example, this really was where anti-SLAPP laws come in and comes into this to plug these gaps. So as has already been commented on, effective anti-SLAPP laws all really carry out the same function. They dispose of cases as early as possible, as soon as they reach the court. They provide protections to minimize the harm caused to those who are targeted by SLAPPs, and they put penalties in place to ensure that those who use SLAPPs are deterred from doing so again in the future. Over the course of 2 legal roundtables that we hosted last year in October and November, we explored how these principles could be adapted in a UK context. And this, looked in part at the individual measures, but also it looked at the extent to which these principles could be accommodated within the framework of the civil procedure rules, and also looked at what precedents exist in UK law, in statutory law, but in common law as well, and the extent to which existing mechanisms might be used or might be underutilized at the moment to deal with the problem of SLAPPs. The outcome of these two roundtables was a set of recommendations, which we launched this time last year at the first JFJ FPC conference. We were handing around a piece of paper with these recommendations, just as now we have the model anti-SLAPP law in the back. So please do take a look. These recommendations included the unambiguous conclusion that we needed an independent anti-SLAPP law. They also included recommendations for how we could reform our civil procedure rules, how we could update our pre-action protocols and practice directions to help with the problem of SLAPPs. It's very much still relevant, still a valid document, but of course our priority at the moment is very much on the anti-SLAPP law. It's important, I think, though, at this point to emphasize that these conclusions and the discussions that preceded them were very much built on a comparative analysis of anti-SLAPP laws that existed worldwide. So on the first of these roundtables, we deconstructed the core components that were included in any effective anti-SLAPP law. So, for example, we compared subjective tests, those which required the court to identify the purpose of the filer, with more objective tests. So those that included, some sort of merits test. And one of the conclusions we reached was very much aligned with what Chris said about an objective test being necessary given the difficulty of such a subjective inquiry. We engaged a number of international experts in this process. Laura, for example, was incredibly helpful. But we also engaged at this point people who were more critical, those people who had things to say about where anti-SLAPP laws worldwide had fallen short, so that we could address those issues head on and ensure that when we were adapting these principles, we could do so in a way which addressed those potential deficiencies. The next task when we had this set of recommendations was to flesh them out into a model law. The purpose of this was really to provide a roadmap for legislators to show exactly how a robust anti-SLAPP law could be drafted in a UK context. At that point, we were somewhat overtaken by events. Early last year, of course, the Ministry of Justice launched their own call for evidence on SLAPPs. And that was a similarly consultative exercise. We were very heartened, for example, to see that experts such as Laura, those who have expertise in anti-SLAPP laws worldwide, were being consulted. I know the Media Law Resource Centre, for example, has a number of experts, people who have been working on this for a while and who were also involved in that. And the document that was published by the MOJ was a well-informed document, one that had an innovative three-part test for disposing of SLAPPs. And again, we welcome that because many of the principles that we had identified, again, as underpinning any effective anti-SLAPP law, you could see reflected in this paper. But we noted at the time that it was really going to come down to details. It was the key details of these different measures that would determine whether or not that this document would provide the foundation for robust anti-SLAPP measures or not. In particular, and this is something I know Rupert said in the first session, but it is worth reiterating, that much will depend on the threshold that those who are targeting acts of public participation need to meet in order to proceed to trial. It's all very well talking about an early dismissal mechanism, but it depends on what test you're subjecting those who are trying to pursue these lawsuits have to meet. It has to be a higher threshold from existing mechanisms for summary judgment, for example, and that's really important. Likewise, we need full compensation for those who have been targeted by SLAPPs and sanctions in place to meaningfully deter those who use SLAPPs. Again, standard cost shifting in this case is not enough, and it really needs more by way of exemplary damages, for example. So this is where the model UK anti-SLAPP law that we have in the back of the room it comes in. It fills these gaps, and it provides for meaningful protections against SLAPPs within the parameters of the MOJ's proposals. It is in that way a very pragmatic document. It addresses many of the points, and it ensures alignment with the MOJ's proposals, addresses many of the criticisms that have sometimes been leveled against those who propose anti-SLAPP laws. I will conclude now, but I'll just say one more thing, which is really going back to Laura's first point, which is this point you were saying, Laura, about the first anti-SLAPP law having been introduced in 1989. You know, that is 33 years of experience we have. That is 33 years of academic literature from people like Chris, from other experts on the functioning of anti-SLAPP laws worldwide. There has been so much experience that we can look to, that we can tap into making this a strong anti-SLAPP law. And I think what we've seen is year by year these laws do become better. They do become stronger. They do take into account experiences from the past. The Washington state law, as Laura was saying, was a law which would be unrecognizable from modern laws. It doesn't have these early dismissal mechanisms that we talk about. It was very narrow in scope. It applied to government petitioning alone. These are very different now. And so obviously I would say this, I would be biased, but I would say that the model UK anti-SLAPP law we have, just like the model EU directive that was drafted a couple of years back and the European Commission's measures, I really do think that these represent the next stage of evolution of these laws, strengthening these laws further still. And there is real opportunity now. The question really is, what appetite is there for the EU, for the UK to ride this momentum? And I think particularly with the UK, and I know it's been said before, but it is worth reiterating, there is such an opportunity here for the UK to lead the way, to go from being a SLAPP pariah to being an anti-SLAPP champion. And if I may commit another social faux pas and end with a cheesy pun, I'll just say that the London here that we are sitting in today, we can go from being a town called Sue to a town called Breakthrough. And that pun took me far too long to come up with. So I am going to finish on that.
It was worth waiting for.
Thank you very much.
Thank you. Thank you so much, Charlie. Maybe I can just abuse my privilege as chair to ask a question, particularly to the seasoned SLAPP fighters, Laura and Chris, and that is this, because you can see that the UK and the EU proposals grapple with this, and that is, to what extent are courts finding a low threshold for proving public participation? In other words, before you can reverse the burden and have the claimant show that the case has merit, substantial merit, or is likely to succeed, whatever threshold you want to impose, how easy is it to convince courts in the US, generally speaking, and in Canada, that it is a case involving public participation? Because, of course, courts around the world can either take a narrow approach to public interest cases or public interest speech, or they can take a broad approach. Laura?
It really goes down to the definition that's in the state statute. And most of the state statutes currently define that very broadly. And so I can tell you, in Texas, we had an interesting experience, because what we did when we originally drafted the law back in 2011, we tried to articulate different topics that were based upon prior case law, had been illuminated to be matters of public interest, things about public health and safety, consumer issues, discussions about government affairs, public officials, things like that. And we had this itemized list. It was a non-exhaustive list, but it was an itemized list in the law that was trying to provide the judiciary with guidance about what was considered public interest. And that actually got met with some resistance. Some of the lessons learned from 30 plus years of jurisdiction and legislation in this area is you also see when a law has gone too far. And we have examples of that. In Texas, what happened was the preceding line to that list, that non-exhaustive list of what is considered public interest, said that it was if the speech at issue or the act at issue related to any of these items was deemed to be basically too broad. And so because too many disputes were falling within the coverage of the SLAPP law, the anti-SLAPP law, there was an outcry to have the law pulled back in a way that actually would have done significant damage. We had essentially efforts to try to repeal the Texas law 10 years after it had been on the books. And what you saw was when we originally got the law passed, there were about a dozen different organizations from both sides of the aisle that had come together as a coalition to get the law passed. When they tried to repeal the law, we had more than 600 organizations come together to stand behind the law. And so instead of the law being repealed, there were tweaks that were made. That relates to language was taken out, the non-exhaustive list was taken out, and instead of providing sort of this itemization of what constitutes a public interest, which was causing some problems, we just looked to U.S. Supreme Court precedent that was more nimble for the courts to be able to approach that particular analysis. And I think the universal impression has been that the way in which the law was reformed has worked very well. One thing that happened in that process, though, was I think lawmakers heard loud and clear, this is an important concept. This is a concept that needs to stay on the books. And in the U.S., we do have the opportunity to have witnesses come and tell their stories. And that was one thing that was brought up in a prior session today, was the need to put a face to, to this issue. And obviously, Daphne's horrific death is what was the wake-up call over here. But what happened was, we ended up having witnesses come from all over the U.S. to a Texas committee hearing to try to preserve our anti-SLAPP law, with 4.5 hours of testimony from SLAPP victim after SLAPP victim after SLAPP victim telling their personal stories about what had happened to them, being on the receiving end of this form of judicial harassment. And that's what resonated with the lawmakers, and that's what resulted in them doing the right thing.
It's always the case studies that bring the law to life. I mean, even in proactive litigation like the South African case, it's about convincing the court that they should care,
right,
or convincing a legislature that it should care.
Exactly.
Chris, in Canada, can we assume that, I know you mentioned in our prep session a recent BC case, can we assume that the courts generally take a broad approach to whether a matter engages public participation?
Yeah, generally the Canadian laws do not enumerate examples of what might trigger a public interest. Rather, I think they have decided to leave it to judicial discretion, which does make sense. I think there's a coherent body of law around what is public interest, and courts are familiar with applying that. So we haven't had that issue. In fact, in most cases that I'm familiar with, or I should say maybe in many cases that I'm familiar with, it's often conceded that that threshold is met and the parties move on from there. It would really only be in a situation where the alleged public interest is really a private interest in disguise, where there's some malice potentially lurking, that I think a court would deny the threshold having been met. But I think Laura's is interesting to hear Laura's comments about how, as the jurisprudence unfolds, courts begin to wonder whether there's any limit to the range of kind of scenarios that the law can be put to use. I think early on in the Canadian setting, many of the cases did not resemble what I think the legislators anticipated they were legislating on. And so I think there will be at some point some effort to revisit the law from that perspective. But we're hoping that the courts can preempt that by providing some guidance on that very matter.
Thanks, Chris. I have a question from the online, and in fact, it's from Prof. Dirk Voorhoof, who's an old friend. So, hi, Dirk. Good to see you watching. And it's for Flutura about the EU package. Do you have any indications about the position of the most important member states of the EU? I'm not sure who those are, and I'm not going to venture a guess. In terms of support for the 27 April package, particularly the directive, and what do you expect the most important hurdles will be on behalf of some of the member states that might be opposed?
Yes, hi Dirk. So with the case, we have working groups working on various aspects of anti-SLAPP, and there is one of the working groups on EU advocacy. What we've been doing since 27th of April this year is collecting intel information on the positions of member states. Some member states have publicly supported anti-SLAPP proposed directive, for example, Austria. Some member states are a bit more reluctant, and some member states are quite hesitant to support the package. We've heard so far two reasons from countries, from member states that are opposing the package, especially the proposed directive. One is member states which think there are no SLAPPs at their national level, and therefore there is no need to address them. And the other reason is with some member states thinking that they already have some legislation in place, not dedicated to anti-SLAPP, but other measures which can help SLAPP cases. Now, what we're doing is we're speaking to ministers of justice in these countries where they are more reluctant or hesitate to support the cases, the proposed directive. We're providing with arguments and evidence why they should support anti-SLAPP proposed directive. And in some countries, we've seen some progress. In some countries, we still have hope that this will be the case. But from the information I have currently, most of the countries are supporting the proposed directive. I know that also Vice President Vera Jourova is personally speaking to a lot of politicians in different member states to try to convince them. And I know also specific members of the European Parliament are very active in trying to convince member states to support it. We're hoping that all these efforts from civil society, politicians, European Commission, European Parliament will help to convince member states. And yeah, I hope this information is helpful to Dirk.
Thank you, Flutter. I noticed you didn't name and shame the member states who think there are no SLAPPs in the jurisdiction.
If I may, I save the name and shame for lawyers mainly. For member states, we will continue to try and convince them to support the proposed directive.
Strategy. I agree with that. Are there questions from the audience? I see we've got a number of hands up. We've got a roaming mic, perhaps on the far left first. Thank you.
Thank you very much. I wonder from those jurisdictions, particularly Texas and BC, maybe others as well, where there have been laws on the books that have been either threatened or taken off the books, who was it who was leading the campaign to repeal that legislation or to block that legislation, and was there astroturfing? Who were the interest groups involved in that, or was it merely a theoretical or an ethical or an ideological position?
Perhaps we should just take all three, and then we'll answer those.
Yes, Craig Oliphant from the Foreign Policy Centre, and thank you very much for the discussion. A question to Laura, and not so much in the spirit of name and shame, but I wondered if you could say something of the 15 or 16 states in the US that have not adopted anti-SLAPP laws. Is there actually a small cluster where you hold out hope that they are moving in that direction? I take your point about the federal aspect. Do you think in terms of a recalcitrant core in that 15 or 16 who are not going to shift, that really the best hope still lies with something at the federal level?
Thank you. And then Joel.
Thanks very much. I'm just interested in the point that Chris made, that in some cases where you can show motive, you can show bad motive and get damages out of that. I'm interested in knowing, one, from Laura, is that anywhere in the US in any of the state laws there? And if so, do people ever manage to meet that threshold? And likewise to Chris, do people meet that threshold? Because as Charlie said, one of the problems for defendants is the best they can ever get out of these things, if they win, is their costs back. And unless you get indemnity costs at the full rate, you are always going to be out of pocket. So I'm quite interested in other routes whereby you might be able to apply a bit of sort of psychological pressure back up the chain.
Thank you. Laura, should we start with you? I think all three questions were directed to you and Chris.
And Chris, okay.
But I'd love Charlie and Flutura to comment too. Yeah.
Sure. So let's start with who tries to get rid of these laws, or who generally opposes the process of getting them passed. And there is always a give and take with the trial lawyers, which I actually find quite interesting, because I feel like the plaintiff's bar is one that generally is known for representing the little guy. And I see these laws as really protecting the little guy. I mean, when you look at SLAPP at its core, it should be appealing to everybody, because it is a law that protects the little guy. It's a law that promotes judicial economy. So those judges that are overworked and underpaid should embrace this sort of law to get these cases off of their docket quicker. And it's a case that promotes core human rights issues. So it should be a win-win-win for everyone. Unfortunately, that's not how it's always received. And so there is some negotiating that has to go on with the plaintiff's bar, typically, sometimes with large corporations. I mean, there were a number of corporations that weren't terribly happy with the law because they were slapping people and on the receiving end of large attorney's fees verdicts against them, which is precisely what the law is intended to do. If you misuse the legal system, then you should have to pay for the other person's fees, which really only brings them whole from a financial standpoint. It doesn't have anything to do with the tax on their mental capacities and the ruinous impact that it can have on a business just while the litigation's going on. So those are typically the opponents. But having said that, there is an opportunity. I mean, when we initially got the law passed in Texas, we worked with the Trial Lawyers Association to get it passed, and we had initially said that the fee shifting provision should apply so that the lawyers and the plaintiffs who filed this lawsuit that shouldn't have been filed to begin with would have to pay back the money. And as soon as we struck the lawyers from that phrase, they got on board. So there's some opportunity there, but I think that speaking to their desire to have an access to justice, they see this as an impediment to them getting to a jury trial. And that is a very core issue for trial lawyers. And I get that. I totally get that. The flip side of that is it is an access to justice issue for the SLAPP victim, because that SLAPP victim now has the opportunity to get counsel and to be able to defend themselves against this form of judicial harassment. So if we can reframe that access to justice issue, that is absolutely imperative in this fight, I think. The second question was about the states that had not passed laws. I'm not sure that it's necessarily that they're recalcitrant or that they don't want to pass them. In fact, a number of those states had the Uniform Law Commission Model Act pending during COVID, and they just didn't get to it in time. So states like North Carolina and Indiana and others, I do think that they will ultimately pass anti-SLAPP legislation, probably in the form of the ULC Model Act. So I also don't see them as being a hurdle to get a federal law passed either. And then Jill, your question, remind me.
About bad
damages. So here's one area where we went too far. Okay, so the way that we've typically done attorney's fees is it's not, I mean, here there is a fee shifting that's sort of partial, and we're used to not having any fee shifting. And so the way that most of the laws are written is if you prevail, you get back your fees. Now the judge has discretion on that, but that discretion is, also met with a fee affidavit that shows exactly how much was spent and how it was spent and all of that. So typically the victim is made whole unless the judge shaves some off, but the way the law is written, they should be made whole. There's also a provision for the judge to enter sanctions. Sanctions against the lawyers or the plaintiff if there's a repeat offender, if they particularly abuse the discovery process, whatever. And those laws have worked very well. The ones where we've gone too far, Washington State actually had an anti-SLAPP law that they passed in 2010, pretty much obliterated by the Washington Supreme Court because it had a liquidated damages provision. It had a $10,000 bounty for each plaintiff that filed the SLAPP suit, and the court said that's gone too far. And so now they had to go back to the drawing board again. They passed 3 anti-SLAPP laws, 89, 2010, and now most recently in 2020 they passed the ULC Act. So you can go too far.
Carly, do you want to comment on perhaps on the issue of damages and so on from a UK perspective?
Absolutely. I'll try and be as quick as possible because I can waffle on endlessly about this. The first thing I would just say was that, I mean, some of these and I know I'm so wary about speaking about the US, and I've got Laura next to me, but in the US, there are a number of so-called slap back motions, right? And that's something you see in other countries as well. So, for example, you can sue someone for malicious prosecution. And one thing that's been interesting in the UK when we were looking at what mechanisms already exist is that we identified that there is already an existing tort of filing a lawsuit of an improper purpose. And this goes back to what we were saying before about the difficulty with engaging that type of subjective inquiry, which is one of the reasons it's underused. But another reason is that if you're requiring someone to file a separate lawsuit, and if you're basing that type of recovery of costs on the basis of a separate cause of action, then it's always going to be underutilized, because the whole point about SLAPPs is it's intended to drain costs.
Sure.
So by the time you get to the end of it, it drains costs. So that's been a very important part when we looked to putting together our model law, because we wanted to make sure that those type of sanctions would be automatically
available,
applicable at the end. That's the first thing to say. One other thing very quickly just to add, only because I do think it's relevant to the UK, to add to what Laura was saying about the opposition to anti-SLAPP laws in the US, which coming from trial lawyers. One thing that's been interesting, as Laura was saying, has been about why Jamie Ruskin's new law has been looks to be more durable because of this alliance of civil society organizations and the trial lawyers lobby. And I think that's very interesting, because one of the groups that has been really active in the US, for example, is Earth Rights International. Likewise, Greenpeace USA, Greenpeace International was also very much involved in strategic litigation. And so there has been some sensitivity from civil society organizations about the danger of having an anti-SLAPP law that could then be weaponized against public interest litigation. The reason I mention that is because that has, to some extent, stopped some civil society organizations from giving it full support. I know Earth Rights International and others have done a lot of work into looking about how this can be addressed, this problem. And you'll see, and this is where I told you there was a point to it, you'll see in our model anti-SLAPP law that there are parts where we have taken that into account. So, for example, when we develop out the definition of an act of public participation, we include a reference to administrative or judicial claims with that in mind. There's also an exception there for public interest litigation. So again, it's an example of where this criticism has been taken on board and used to make these provisions stronger.
And a reminder to everyone to please get a copy of that draft law, which is at the back of the room.
Good read.
If you haven't seen it already. Chris, I'm conscious that we don't leave you or Flatura out. Perhaps you could deal with the questions around, the campaign against the laws in BC, who was leading that, and then the issue about bad motive and damages.
Absolutely. So let me talk about damages first. We litigated a case that was decided in August, where there was extensive cross-examination on affidavits, and the evidence was very compelling, we thought, from the plaintiffs directly about what their motives were. Notwithstanding that, although the judge dismissed all of their claims on the motion, he was reluctant to take the next step, which was to find bad faith or improper purpose. And I think there still isn't a BC case where damages have been awarded under that provision. There are about 6 cases, I believe, in Ontario where damages have been awarded, but they tend to be an afterthought. The damages tend to be fairly small. I think they cap out at around 20,000 Canadian, which is a trifling amount compared to the lawyers' fees, which are also awarded in those kinds of cases. So I guess conceptually, I think it's important in these laws for us to park the issue of improper purpose, for that not to be a barrier to getting a case dismissed. But by parking it and moving that issue to the damages phase, I don't think we're any further ahead in terms of encouraging courts to approach this from a compensatory point of view. There's still a very strong reluctance on summary motion to, at least in Canada, to reach the conclusion that the plaintiff brought this for an improper purpose. As for the background to, in BC, the opposition to the original law back in 2000, I think the trial lawyers had something to do with it. I think it was also that the law was brought in a somewhat rushed fashion towards the end of the electoral term of a government, and it was early on. This was early days. 20 years later, what is fascinating is that the law passed unanimously. There was not a single opposition member who spoke against the law. And so I think there is a generational change afoot. We are warming up to the recognition that our legal system doesn't contain proper protections here, and that we need to do something about it. And of course, in the intervening time, the Supreme Court of Canada has also said the same thing in terms of pronouncing on defamation law. So, I think we are in a different time now than we were in 2000. The other thing that was done in Ontario that I think was helpful was that the government, before introducing the law, commissioned a blue ribbon panel chaired by the dean of the Toronto Law School to offer them independent recommendations on the issue. And I think that also helped to mitigate opposition when the law was brought in, because the panel strongly came out in favor of a law, and many of its recommendations are reflected in the law.
That speaks to the importance of advocacy efforts and the kind of initiatives that are going on in the UK and in Europe, and the importance of keeping that momentum up. Prather, do you want to add anything on any of the issues?
Very briefly on the opposition, I think in Europe we were very lucky because so far we haven't seen any organized or orchestrated opposition from any interest groups. We have heard some individuals, be that within the European Parliament, but also scholars who oppose the whole idea of introducing EU measures on anti-SLAPP, but these are very limited voices. So we're lucky on that. And secondly, I just wanted to share this information for those who are less familiar. We heard about several states within, be that US or also in other continents, taking measures. Now in Europe, apart from having the proposed a package from the European Union, there are also member states which at national level are introducing anti-SLAPP legislation. The UK was mentioned and elaborated in detail throughout the day, but also other countries like Lithuania, Ireland, and Malta. Now, one thing that I wanted to say in this panel is the importance of including civil society throughout the process of drafting legislation, and we can see the difference in those countries where the authorities, for example, in UK, collaborate with civil society. I know from my friends in UK that the Ministry of Justice works closely with civil society. They listen to them. They try to accommodate their suggestions, etc. But we also have countries like Malta, which are not doing that great in consulting civil society. We already have some measures, legislative measures introduced there, but quite a lot of concerns with regard to lack of a meaningful consultation with civil society. So to conclude on this aspect, I think working closely with civil society is absolutely key to have adequate anti-SLAPP legislation at national level.
That is critical, and I think of your conference a month ago where the representative from Malta did face some quite heavy fire on the issue of consultation. So it's a point well made. Yeah, we've got time for a couple more questions. So yeah, please, if we could have the roving mic.
One of the conversations we're having at the UK Coalition is the idea of enforcement of foreign judgments. And it's still something we're discussing. And I'm just wondering from the panel from Canada, South Africa, the EU, the US, how other jurisdictions have approached that, because there's no good having strong anti-SLAPP provisions if the courts can be used to almost codify a weaker mechanism elsewhere.
Yeah, absolutely. Laura, in the US?
We've passed a separate law addressing that.
To address that.
Yeah. So we won't acknowledge the foreign judgment if it doesn't comply with our constitutional standards. That was a separate law.
And that would include the SLAPP standard, I mean, presumably.
Well, it includes constitutional standards. There's not a federal anti-SLAPP law.
Yeah.
So.
Okay. So that just points to that lacuna still. Charlie?
Well, I mean, I was from the UK. We looked at this. I don't want to preempt what Prather might say on this, but it is, I think, one of the most exciting parts of the proposed directive from the European Commission, Chapter 5, that deals with exactly this and would block enforcement of such laws, and also provide a means for those who have been targeted outside of the EU to claim compensation. I don't have an answer about the UK, but it's certainly, I think, an important thing to look into, especially when you've got the Commission as a model there.
Perhaps let's go to Flatura.
Nothing to add. I hope this very strong part of the proposed directive will not be weakened during the process of approval. So let's see what happens.
Thanks, Flatura. And Chris?
Yes, our situation is substantially similar to the way that Laura has described it.
Yeah, I mean, from a South African perspective, we haven't yet faced something similar at all. But, while we defer to the principle of comity amongst countries and therefore generally recognize foreign judgments, certainly in the context, for example, of extradition, we won't extradite people to countries that have the death penalty. And certainly from a public policy perspective, I've no doubt that South African courts would not enforce a judgment which is radically different to our constitutional standards. So, but yeah, certainly a lot of development still required. I think we have time for a couple more questions if there are any. There must be some burning issues. Perhaps we should just go around and do some concluding comments. And perhaps let's start with our with the virtual participants this time. Chris?
Yeah, I think it's very exciting to see this energy and momentum that you've been able to generate, and the synergy between UK and EU, and the opportunity, as Charlie's pointed out, the opportunity for the UK to take leadership here. I think the challenge always is to adapt this concept of SLAPPs to national settings in a nuanced way. I think we've managed to do that. It's taken us a while in Canada to do that, but yeah, I think we have managed to create a constituency that supports the need for a law, and we're working away at trying to make the law work. And I'm hoping that we'll be able to consolidate the progress that we've made. And look to supporting efforts elsewhere, because I think that the more this becomes a concept that is broadly accepted and is being dealt with nationally in a variety of ways, the more that I think we can be secure in the expectation that there will continue to be laws on the books to protect public participation.
Thanks, Chris. Prather?
Yes, so I started by saying that we can be proud of what we have achieved as case in the last 3-4 years. We have managed to mobilize every single European institution, European Parliament, Council of Europe, European Commission, OSCE media representative, and all other relevant institutions to counter SLAPPs in one way or another. They have all started to take measures. So this is something to be proud. I think our agenda in the upcoming months, especially, but also years, is very clear. To convince those reluctant member states at the European Union level to support the proposed directive, to join forces with civil society to support SLAPP victims in the meantime, because they need support. But also, and for us this is very important, is to push for the implementation of the recommendation on anti-SLAPP. The recommendation has entered into force. So for all, especially civil society organizations doing a lot of fact-finding missions, working at national level, I think a question for all ministers of justice or other relevant governmental ministries is what steps they have taken to implement the recommendation. So it's very high on the agenda for us to push for its implementation.
Yep, thanks very much. Charlie, some concluding remarks?
I'll be as quick as possible and just say, look, the principles here, principles that can be found on the first page of the model anti-SLAPP law, they're not controversial. You know, it has long been recognized in the English common law and beyond that a lawsuit filed with an improper purpose is an abusive lawsuit. It has long been recognized that an abusive lawsuit has no place in our courts of law, and that they need to be disposed of and filtered out of the process. The question is how this is done, and how can it be done quickly enough to neuter the impact of SLAPPs. And as I said at the end of my speech earlier, you know, we have 33 years of experience of anti-SLAPP laws, of the way they've been operating to look at. We've got the expertise of brilliant lawyers like Laura and Chris and Prather that we can lean on. It's all there, you know. This shouldn't be controversial, and I really would encourage people to engage constructively with this. There are obviously questions and details and legitimate criticism, but there's also a hell of a lot out there that we can refer to address those points. Should do.
Thank you. All right.
So I've had the pleasure over the last few months of being able to observe and participate in what's going on in the EU and in the UK and compare that to the US. And I'd like to just highlight some of the issues that are being done really, really well here, much better than we've done in the US. Mapping the problem. Mapping the problem is a key issue, and it has been done extraordinarily well through the Council of Europe, through the Case Coalition, through mapping media freedom, etc. And that's important because that tells lawmakers that there is a need and that need needs to be addressed. Naming and shaming. Even though we have protections in the US, we don't name and shame. Y'all do. That's actually a great way of raising awareness, and that's wonderful. holding lawyers accountable, what we were talking about earlier today with the SRA and what's being done there. That is absolutely critical and not something that I feel like we do a good job of in the U.S. And getting judges involved in the process. Actually asking the judges for their opinion during the consultation is a hugely wise thing to do, because you have to get them on board if they are going to be the ones implementing the law and having to take this active case management. The one bit of advice that I would give from a U.S. perspective is we have wonderful organizations like the Media Law Resource Center that bring together people that practice in this space, and we tell stories, not just stories, but we exchange information, and we help with the advocacy part of it in the courtroom and in the legislature. And International Bar Association is one of the fabulous co-sponsors here today, and that is a phenomenal organization that can also provide help in that space, because actually what we're dealing with here is a global phenomenon. It's a global assault on human rights issues, and it's something where the legal framework and the network can really provide the resources to help SLAPP victims and to help advocate for change. And so if we can better utilize those networks, then I think that will better support everyone.
Absolutely, and of course the high-level panel is part of those networks, which I want to remind everyone about. Thank you so much. It's been an absolutely incredibly interesting discussion. I hope 2023 is a big year for the US as well as the UK and the EU, and perhaps when we meet in about a year's time, if we do, there'll be some very positive report backs. It's a little bit for me like the defense of responsible or reasonable publication in defamation law, which kind of started filtering through at a common law level in the UK, and within a year or two that it had influenced developments in Australia, in New Zealand, in South Africa, and court cases were sort of winding their way through these systems and influencing each other. But later Canada came on board, India, Pakistan, many African countries now have that reasonable publication defense, which sort of liberated defamation law from the strictures of the truth defense. And in a way, this feels to me like it's the anti-SLAPP moment, because of all this momentum that we've been hearing about. And I think our panel deserves a round of applause. Thank you. Thanks so much.